This document we are asking you to sign is called the Individual Settlement Agreement and Release. For the rest of the video, I will refer to this document as the release. By signing the release, you will become eligible to submit a claim for compensation from the $4 billion settlement fund. I urge you to read the full release and make sure you understand what you're signing. To help you better understand, in this video, I will be providing you with a very detailed overview, paragraph by paragraph, of the entire release. The release will be shown on the screen while I'm speaking, so I recommend you pause and read the release as needed. Let's get started. Article 1. Recitals. In a release, recitals provide a background about the facts of the case. They help to give some context to the release and help explain why the parties are entering into the settlement. Here's a quick overview of the facts and process presented in the recitals. Simply put, the release does three things. Number one, the release creates the Individual Settlement Fund. The Individual Settlement Fund is the $4 billion that Hawaiian Electric, Bishop Estate, the state of Hawaii, and others have agreed to pay compensation to the victims. Number two, the release appoints the individual settlement administrators. The administrators govern the fund and will be responsible for evaluating your claim and deciding how much money you should get. Number three, the release directs the administrators to create the Individual Settlement Plan, or ISP. The ISP governs how the fund will value and pay your claims. We will use the ISP rules to make the strongest case for you. We do this through your case management and by me and my team analyzing and evaluating your narratives, your documents, and all of the facts of your particular case to present your claim in the best possible way. By signing the release, you're also agreeing that you understand what you are signing, that you're signing all the terms of the release, and that you have asked me and my team any questions that you may have. You're also agreeing and understanding that signing the release is necessary to make you eligible to submit a claim to the settlement fund, and that the release is irrevocable once signed. Lastly, as part of the settlement, defendants, which is Hawaiian Electric, Bishop Estate, the state of Hawaii, and other parties, deny any liability or wrongdoing related to the fires. I understand that this statement might be confusing and frustrating, but please rest assured that even though they are not admitting it, the fact that they are paying $4 billion shows us that the defendants know that they caused and contributed to the fires and to all of your losses. Article 2. Definitions. Definitions are exactly that. They explain the meaning of the certain important words that are used in the release. Plaintiff. Plaintiff refers to you or your authorized representative. Release claims. The term release claims refers to any claim arising from the Maui fires. This includes future claims that may arise later. Releasees refers to Hawaiian Electric, Bishop Estate, the state of Hawaii, and all other defendants in this matter, including their subsidiaries and employees and other companies related to them. Here is a list of all of the releasees. Releasors also refers to you, but this definition also includes your parents, children, spouse, representative, employees, and others associated with yourself. Article 3. Release. Paragraph 3.1 through 3.6 says that in exchange for payment, you are agreeing to release your claims you have against the defendants for your losses related to the fires. There are a few points I want to make sure to highlight. By signing the release, you understand that the money you will receive under the settlement plan constitutes the full compensation you will be receiving. There will not be any other process after this one. This release includes all claims, present and future. What this means is that by receiving compensation from the defendants, if something comes up in the future relating to or resulting in any way from the fires, you will not have the right to pursue those claims. Another important point is that if you sign this agreement and then decide to file a lawsuit related to the Maui fires, you may be responsible for legal costs, fees, and other expenses associated with the lawsuit. This is because you have previously agreed not to sue the defendants. Last, By signing, you also promise that you have not given or sold any part of your case to anyone else. Also, if you are involved in any bankruptcy proceedings, you can still participate, but please let us know as soon as possible so that we can ensure all the bankruptcy rules are followed. Article 4. Certain acknowledgments by releasor. 4.1. Voluntary agreement. You understand that you are agreeing to the settlement voluntarily, without being pressured or influenced by anyone involved in the case. You are aware and accept the terms of the settlement and confirm that you had a chance to ask questions and speak with myself or any of the other attorneys, and all of your questions were answered to your satisfaction. 4.2. Condition to monetary award. You understand that you must submit this release on time in order to receive any money from the settlement. We will help you make sure your release is submitted on time. 4.3. Liens. The money you receive from the settlement may be reduced by certain debts that must be paid first. This is what we have been fighting the insurance companies on in court over the past year. If you have received no insurance money, this will not apply to you. What is important to know is that you will never owe money to your insurance from your net settlement. We will work with the insurance to negotiate any possible repayment down as much as possible to get you the most money in your pocket. 4.4. Apportionment of payment to medical lien holders, and 4.5. Medical lien indemnification. This section only applies if you are injured and received medical treatment. If this applies to you, what this means is that your medical provider may be entitled to reimbursement from the settlement. Again, don't worry, we will take care of this for you in the lien process. 4.6. Taxes. You will be responsible for paying any taxes on the settlement money you receive. Thankfully, in 2024, the Federal Disaster Tax Relief Act of 2023 was signed into law. This hopefully will exempt most, if not all, of your settlement from taxes. However, I cannot promise or guarantee anything, and it would be in your best interest to talk to your tax person about this if you have any questions. 4.7. One-Ohana Fund. This paragraph is only applicable to wrongful death claims and serious injury claims. If you have a wrongful death claim or injury claim, we will work with you to ensure you are properly registered with the One-Ohana Fund so that you are eligible to make a claim also to the individual settlement fund. 4.8. Dismissal with prejudice. If a lawsuit was filed for your case, it must be dismissed in order for you to proceed with the settlement. We will take care of this for you. 4.9. Timing of the release. The release is not effective until the defendants make their first payment into the settlement fund. 4.10. No admission of fault or liability. I want to start by saying that this paragraph is standard in all releases. What this means is that the purpose of the release is just to reach a settlement of your claim, and that it cannot be used against the defendant as proof that they were at fault. For example, if someone decided to sue Hawaiian Electric in the future, they cannot use this specific document as proof that Hawaiian Electric was at fault for the fires. 4.11. Modification. This release can only be modified with the authorization of all the parties. 4.12. Entire agreement. This paragraph says that this release, together with all the other documents that came before this, constitutes the entire agreement between the parties. If there are inconsistencies, then the individual settlement agreement and individual settlement plan control. Please let me know if you would like copies of the individual settlement agreement and individual settlement plan. 4.13. Severability. If any part of the release is determined to be invalid, the rest of the release is still valid and effective. 4.14. No construction against any party. This simply means that the language of the release is neutral and it does not favor one party over the other. 4.15 or 15. Governing law. This release is to be interpreted under Hawaii contract law. As a personal injury lawyer for over 40 years, I have seen thousands of releases, and most of this release is what we call standard language. And I've pointed out the most important parts I want to make sure you understand. 4.16. The electronic signatures. The release can be signed electronically, and an electronic signature has the same effect as a wet signature. We urge you to sign the release electronically, but if you cannot do this, please contact us and we will get a paper copy for you to sign. And finally, 4.18, jurisdiction of the court. Any disputes related to the release will be resolved in Maui using Hawaii laws. And that is the release. If you are still unsure, you might be asking, what are my other options? Well, you have 3 options in total. Number 1, sign the release and submit your claim for compensation from the individual settlement fund. Number 2, join the class action. And thirdly, file and pursue a lawsuit. I am recommending that you sign the release. I am not recommending the other 2 options. I do not advise the class action for a number of reasons. Their fund is limited to $135 million. Secondly, you will not have your own individual lawyer to help you submit your claim. Probably the most important reason the class will not be best for you is that the class consists of all kinds of claims. It also includes businesses who suffered as a result of a decline in tourism, and also includes tourists who lost money because they could not come to Maui. This opens the door for thousands of tourists and businesses to make a claim against the $135 million class fund. By joining the class, you may be competing against large businesses outside the burn zone who are making a claim against this limited class action fund. The other option is to pursue a lawsuit against the defendants. There are a number of reasons why this is not best for you, but the 2 most important reasons is time and money. I know from my other cases that the court is setting trial dates in 2027, therefore time should be a big factor in your decision. The other reason is money, the cost of litigation. It will cost hundreds or thousands of dollars to take this case to trial. These expenses will all come out of your verdict and awarded judgment. This is simply not a wise decision. Again, I do not recommend either of those options. The best choice for you is to sign the release. The time to act is now, and if you have any questions or need more clarity, please reach out and we'll be glad to meet with you. This is not something that can wait. Of course, if you have any questions, need more clarity, or want to know how a portion applies to your specific case, please just call us and we will be happy to answer your questions.